to, or make you think that it's close to some value or something. So it ends up, there's ways to go around it, but just I want you to understand it's difficult, but sometimes you can do that. This is actually kind of similar, but, and I apologize because my eye should be over. When you prepare a patent application, I think some of these other slides are along the same genre, and I'm thinking of maybe keeping my lecture short, which would be a little bit, maybe you need more time for people. Unusual for a lawyer, I suppose, but I'm also thinking that it's not the most interesting topic for all of you. But I think in preparing a patent application, there's some requirements of having a complete written description. It has to be enabling disclosure to the public. When you draft claims to protect your technology, it has to be in clear terms. And many of these terms that are being used are not widely understood terms. How do you focus your intent? What does it mean by your intent? Feeling of, certain types of things you have to mentally do, and you describe that in terms which the patent office will not understand. And so it's, I think it can be very difficult to draft applications and to focus a patent in a way that would actually be acceptable. Well, I guess one other thing, and I think this is probably important for people here too, is if you are ever thinking about obtaining a patent, is there's a time requirement to get it into the patent office. If you publish your technology, you basically have a 1-year period within which to file something. So that can kind of start a ball rolling. You have to actually get moving into the patent office. However, sometimes you don't know when you're going to market something. You start at the beginning going, I think I was sitting there and that thing buzzed right when it's like you get these ideas and then you come out and give a lecture about that, and before you know it, you've got 3 years of background disclosures before you realize the invention. And so you can kind of create all these earlier disclosures become prior art against yourself. So it's like you create kind of a situation where it's difficult to be patenting. So I think it ends up, you end up with this balance of, if you want to try to protect things, is some things should be trade secret, some things you can maybe disclose. And actually with that, I think that sometimes when people decide, well, I'll just disclose the general stuff, well, sometimes the general stuff is enough to negate the possibility of the patent, because when you apply at the patent office, sometimes you're just speaking in very general terms. So I think that one's an important thing to understand, and I think it's definitely a problem in areas where you might, some of the ideas that people are working on now might be in inventions in 20 years from now. Maybe people will be doing a lot of things with random event generators or other things long-term down the road, but who knows, when you try to think about patenting now. I think this is maybe not the best organized. This is a really more of a reiteration of some of the concepts that the emerging technologies are more, I think, complex, based on principles that are not so well understood, and I think a lot of times difficult to identify the inventive aspect. A lot of things, like you can obtain a patent when you know you do a certain process. You obtain a patent on a process when you know the outcome is something, and you take certain steps to get there. But if you don't understand what it is that's happening along the way, it's hard to get a patent on that. And like I think about the remote viewing, it's something that I've been into now, and like, yeah, for me, I see things, and they're really close to the stuff that's there. I don't exactly know why. People talk about it's the higher self, it's the this, it's that. I don't know what's happening. So can I identify what it is that, in a way that's clear and concise that the patent office would like it? I think it would be pretty hard. This is a slide that just goes into talking about some of the complexities of software. And I think I was thinking of focusing more on software because I think a lot of the inventions that you guys might have would probably be in software-related areas. And one of the problems with software is a lot of times you maybe have, you're trying to have interactions between different devices, maybe a server that's located anywhere in the world. You have people in different countries sending data back and forth. It can be a lot more complicated than to patent a system that you can put on your desk and identify the components. And another thing with software, a lot of times, and you end up with, the inventor comes up with an idea, hires some programmer to do some stuff, gives them general guidelines, and before you know it, you got the programmer working on stuff, and then it's a matter of, well, who invented this? Where's the invention lie? And I think that's one of the reasons I brought up before is, contracts. It's very important when you are working with people that if you're hiring someone for a task, make sure you own the technology. I only have 20 more slides. So I threw in something about the types of patent applications. Basically, there's also plant patents, which I would think that I don't really know anything about. And nobody, I would think, would care too much about them. But perhaps in this room, some people can find invention and I wouldn't think of. That's right, yes. If you're talking to plants, perhaps come to me afterwards and I'll find out some more information. But there's basically, there's utility patent applications, which basically the main type, which is focusing on technical inventions. And there's design patents, which focus on the way something looks, the ornamentation of it. And there's two procedural things. You can sometimes file before a talk. Oh no, I'm giving a talk tomorrow. You can file a provisional application, which is more of a filing mechanism to get you into the patent office more quickly. And that is the end of my talk. Thank you very much.
All right, we can have questions now.
Sure.
Garrett,
Oh.
why don't you start?
So, first of all, I want to say thanks for coming and talking to us about patents. I believe it's an important, patenting is an important function, particularly for the sorts of directions that the SSE is going in. Because if a company wants to develop a technology, they will only invest in it if they know they can own it. And so having a patent provides a real function in enabling a company to own something and therefore invest and make it real. And tomorrow I'll be talking about a number of different patents in zero-point energy technology. And these patents have produced investment and the ability to try to develop these technologies. And it is something that we should be getting into more and more. And I just want to say I think this is a good thing. It's a good thing for industry in general, and I think it's a good thing for the direction the SSE is going to be going.
So let me ask the question.
Sure.
If you have an invention, you own one patent, and you want to release it to the public realm, and you don't patent it, if someone else then come in and patent it, take it and lock it up?
Well, that's where you run into issues if there's trade secrets. If you keep your invention behind closed doors,
No, you want to release
then
it.
right. If you, I'm sort of explaining that. If you hide it, then someone could come out and patent it. If you disclose it, you can actually then prevent others from being able to patent it. One of the things you might run into is you disclose it, and what is it? You might disclose the basic idea, and then someone comes out and finds the little improvement and patents that and stops the whole world. So it's like sometimes being the first to disclose doesn't necessarily mean that you've protected the whole area. And that's actually very common to have later comers with more power from that.
This is another comment. A lot of you are associated with universities, and you have to be very careful because they all have policies, technology transfer policies, and if you get something while you're in the school, the question comes up, who owns it, you, the school, or some combination? And most of the universities have very specific guidelines on what goes to you and what goes to them. And some of them don't have any of these guidelines, and in that case it belongs to you. So you got to make sure you understand what all that is. You're defending something within the university or education.
I think I was going to add that I've actually done patent work with the University of Virginia. A good friend of mine is actually patent counsel here. And it took me a while to actually admit to him some of the research I was doing